If you thought this case was already disturbing, the latest hearing made one thing impossible to ignore: the timeline is starting to look bigger, messier, and potentially more revealing than many people first understood. And the reason people are focusing so intensely on this moment is not just because of one allegation, but because prosecutors, investigators, and online observers are now looking at whether the same time period could point to a broader pattern of conduct rather than an isolated incident. At the center of the discussion is the timeline surrounding Celeste Rivas Hernandez and the allegation that, on February 14, 2024, she was encouraged to leave home, pack her things quickly, and meet up away from her house. If that allegation is proven in court, it becomes a major turning point in how people interpret everything that happened after. But that is only part of why the hearing drew so much attention. The other reason is that testimony and commentary surrounding the case have raised questions about whether another minor may also have been present in the orbit of the accused during that same period. That second piece is where the public conversation gets even more serious, because if investigators and prosecutors can establish a repeating pattern, then this stops looking like a narrow dispute over one event and starts becoming a broader argument about behavior, access, knowledge, and intent. And to be clear, that does not mean guilt has been proven. It means the stakes of the case rise dramatically when multiple alleged points on the same timeline begin to overlap. According to the discussion that has emerged around the hearing, one claim is that while Celeste was allegedly being hidden or housed in one location, another minor was allegedly at a different residence connected to the same adult during the same general time frame. That claim matters because prosecutors in cases involving exploitation or grooming often look for repetition, overlap, compartmentalization, and logistical planning. In other words, they look for whether the facts suggest chaos or a system. And that is why so many people are now revisiting details from mid-February of 2024. Because if the court record, witness testimony, phone data, digital evidence, or photographs show that different minors were allegedly being managed, moved, contacted, or concealed at roughly the same time, that could become one of the most powerful narrative points in the entire trial. Not because online commentary says so, but because pattern evidence, if admitted and supported, can influence how a jury understands motive and credibility. Another point fueling scrutiny is the allegation that, days after Celeste initially went missing, law enforcement contacted the accused and asked whether he had seen her. The claim being discussed publicly is that he denied recent contact. If that allegation is backed up by evidence, it may become relevant not only to the factual timeline but also to credibility. In a case like this, credibility is everything. Juries do not just weigh isolated facts. They weigh whether a person's statements line up with the digital trail, witness accounts, and subsequent developments. Then there is the issue of outside warnings. Public commentary around the case has highlighted an email allegedly sent to management, warning that the missing girl was underage and urging that she be returned home if there was any truth to the rumors. If documentation confirms that such a warning was received and forwarded, that detail could become highly significant. Why? Because one of the recurring questions in cases like this is not only what the accused knew, but what people around him knew, when they knew it, and what they did after being warned. That part of the story shifts the focus beyond a single defendant and into the surrounding environment. Again, that does not automatically create criminal liability for other people. But in the court of public opinion, and sometimes in the evidentiary logic of a real trial, the surrounding circle becomes part of the story. Were there red flags? Were there rumors? Were there direct warnings? Were there opportunities to intervene? Those questions matter because they shape how the public interprets silence, inaction, or continued association. Another reason this hearing changed the tone is that the case no longer feels hypothetical to many observers. Early public discussion can sometimes be speculative, chaotic, and incomplete. But once hearings begin and names, dates, and factual disputes enter a courtroom setting, the conversation shifts. People stop asking only whether the allegations are shocking. They start asking whether the timeline is corroborated, whether witnesses are consistent, and whether the prosecution can establish intent beyond isolated coincidence. And that is where the larger pattern argument comes back into focus. Because when multiple details point to the same period, the same residences, the same alleged methods of contact, and the same age-related concerns, the prosecution's story becomes easier for the public to understand, not random, not accidental, not misunderstood, but potentially organized. Of course, the defense will likely challenge every one of those inferences. The defense may argue exaggeration, misinterpretation, unreliable witnesses, or selective storytelling. That is exactly what high-stakes cases are built on, competing explanations of the same timeline. Still, what makes this moment so volatile is that the timeline is not just emotionally disturbing. It is structurally dangerous for the defense if prosecutors can tie the pieces together. One allegation alone can be denied as a lie. One witness can be attacked as confused or biased. One bad-looking message can be dismissed as taken out of context. But when separate details start supporting each other, the burden on the defense becomes much heavier. Then the question is no longer, can this one piece be explained away? It becomes, can all of these pieces be explained away at the same time? And that is why the hearing resonated so strongly online. People are not just reacting to one accusation. They are reacting to the possibility that the case may reveal a pattern of conduct that was hidden in plain sight. A pattern supported, if prosecutors can prove it, by movement, communication, denials, third-party warnings, and more than one alleged underage connection during the same stretch of time. What also stands out is how often these cases turn on the smallest details. A date. A lease. A ride. A message. A missing person poster. A phone call. A forwarded email. A photograph that places somebody somewhere they previously denied being. In everyday life, those details can sound ordinary. In court, they can become the scaffolding of the entire case. That is why investigators obsess over sequence. Once sequence is locked in, motive and knowledge are argued through that structure. If the prosecution can show that an underage girl was missing, that warnings were circulating, that communication channels were active, and that the accused had reason to know exactly how serious the situation was, then the narrative becomes much harder to contain. If the defense can undermine those same links, then the prosecution's broader pattern argument weakens. That is the battleground. Not outrage alone. Not commentary alone. Sequence, credibility, corroboration. And the reason the public is now paying closer attention than before is because the hearing appears to have given observers more than rumors. It gave them a sharper theory of the case. A theory built around overlapping dates, overlapping locations, overlapping warnings, and overlapping alleged victims. Whether that theory ultimately holds up is a question for the court. But it is precisely the kind of theory that can transform public perception of a case long before a verdict is reached. There is also a wider social reason this story is hitting so hard. Cases involving minors trigger a different level of moral attention because they immediately raise questions about power, manipulation, access, and adult responsibility. Even before legal outcomes are decided, the emotional temperature is much higher. And when allegations suggest not just a single breach but a possible pattern, the sense of alarm multiplies. That is why every future hearing will matter. Every evidentiary ruling. Every witness statement. Every contradiction. Every attempt by either side to frame the same timeline in a different light. Because from this point forward, the central fight may not be over whether the accusations sound terrible. The central fight may be over whether prosecutors can prove that the terrible explanation is the true one. For now, the most responsible conclusion is also the most unsatisfying one. The hearing raised serious questions, sharpened the pattern argument, and increased the stakes dramatically, but allegations are not convictions, and online narratives are not verdicts. The next phase will depend on what can actually be documented, admitted, and defended in court. But if this latest hearing did anything, it changed the lens. People are no longer looking at the case as a single shocking allegation floating by itself. They are looking at a web of dates, movements, warnings, and possible overlaps. And if that web keeps tightening, the public conversation around this trial is only going to get more intense from here.